from her about law clerk examination, of course, but insights of uh, how is the experience for working in Supreme Court of India so close to justice. So over to you, ma'am.
Hello, hi everyone. Good evening.
Ma'am, you're not audible.
One second. Am I audible?
No,
No,
ma'am.
Yes,
Yes.
audio, yes, audio.
it's audible.
Yes, 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 yes.
Okay, okay, okay. Hello everyone. Neha, like Khushi just said, I worked with Justice Rishikesh Roy for 1.5 years as a law clerk. I wrote the exam in 2023. So I'm hoping to tell you all about my experience. And I think Hitanshu and I decided that both of us can together tell you so that it will be much more beneficial and time saving as well. Um,
So yes, we also have our second guest, Hitanshu sir. Hitanshu sir has done his PLLB honors from ILS Pune and has served as law clerk cum research assistant in Supreme Court of India. He has done his LLM from NUJS Kolkata and he can tell us more about law clerk cum research associate and how is the experience working at the Supreme Court of India as research assistant also. So over to you, sir.
Thank you. Thank you so much, Kushi. I hope I'm audible though.
yes.
Yes, great, great. I hope we, both of us, me and Neha, give you insights that are actually valuable to you. And they help you into clearing the exam and working there as well. So I think, are we good to start? Yeah, I think then Neha could start with the
Um,
presentation.
yes. Khushi, can you please share the PPT?
Sure, ma'am, sure.
Yes. Um, okay, so first of all, we would talk about who is a judicial law clerk and what are their responsibilities, right? So when we were in law school, when I was in law school, I was not much aware about this position called as a law clerk cum researcher at the Supreme Court of India. Many of my classmates had done their internships in High Court or internships with advocates at the Supreme Court. So when this notification came up that there is an opportunity to work closely with the Supreme Court judge, I was very excited and I didn't know much about it. But having worked at with a judge now, I can tell you in brief what are the responsibilities that this position comes with. Um, I'm sure all of you must have gone through the scheme for engagement of law clerks that Supreme Court has published. It highlights the duties and responsibilities in a very brief and a narrow manner. Firstly, a law clerk is associated with one of the judges of the Supreme Court of India. So currently, our strength is, I think, 32. So if you clear the exam, you are attached to one of the judges of the Supreme Court. And their most important duty is to prepare brief for hearing that the matters that are listed on the next date. So traditionally in a Supreme Court, Mondays and Fridays would be miscellaneous days, which means that around 60 matters get listed, and these are fresh matters which are either of civil nature or of a criminal nature. So, as a law clerk, your duty is that before 1 or 2 days before the matters are listed, you go through the pleadings that the advocates must have filed. And then, if sometimes pleadings can run into 100, 200, 300 pages, your job is to make it concise and make it into a one-page note so that the judge can read it and understand in brief what the matter is all about. So this brief making is what my colleagues would call as the bread and butter of a law clerk's job or a duty, because you spend all most of your time in clerkship making briefs. So I believe that it gives you a very good opportunity to understand what are the different matters that Supreme Court of India deals with. We know that it is the appellate court of the country. So from all high courts, the appeal lies to the Supreme Court. Sometimes it also has original jurisdiction, which means writ petitions can also be filed, right? So under Article 32 of the Constitution. So these kind of pleadings, you as a law clerk will get to read even before the judge gets to read it. So that's such an impressive and a good opportunity. You get to read it and then make a brief of it. So well, later on, we'll tell you how the brief is expected by the judges, and even the exam tests you on your ability to make a brief. So, this is one part of a law clerk's duty. Then there is preparation of research notes or helping the judge with drafting of the judgments. Um, so, whenever a matter is heard and judgment is reserved by the judge, in the residential office, the clerk is expected to research on the legal issues, the factual matrix, and then prepare a research note. Or sometimes, even the judge allows the clerk to prepare a draft order or a draft note, which the judge can maybe use in their judgment when they are when they are drafting the judgment. So, this is such a big opportunity that as law students or just like early career legal scholars, we get to read matters that have taken years to come to the Supreme Court, but then you are working on it and you get to give your research inputs. So this is the second duty that is there. And the third one mostly came up when I was clerking with Justice Roy was a judge also has engagements outside the court, because they are Supreme Court judges. They are invited to many events which are related to the law. For example, they may be invited to go to the High Court and address judicial officers about the conduct and give them training. So, as law clerks, then we also help them, give them speech pointers or give them even draft speeches which they can use to address the gathering. So this is the other duty that comes up apart from the normal brief making that a law clerk is expected to do. I think Hitanshu has worked with the registry as well in the e-committee, so he can also tell you what is the other aspect of the clerkship which is involved.
Right. So basically, when you are engaged as a law clerk at the Supreme Court, there are two ways you'll be functioning. One, primarily, you're appointed at a judge's residential office. If not, the second appointment that happens or takes place is in the various departments of the Supreme Court's registry. Now, there are various departments. There's CRP, that is a Center for Research and Planning, which takes up a lot of majority of the Supreme Court's entire research and publication process. Then there's the committee, which controls the entire e-courts project that runs throughout the country. So any and everything regarding digitization of the judiciary, right from the trial court to the Supreme Court, that is controlled by the committee and various other departments as well. So I worked in the e-committee. Now again, because when you're working with departments, these are not justices. So the part where you consider brief making is not entirely, I wouldn't say entirely absent, but that is not a part of your regular work profile. What do you do in these departments as a law clerk is multiple times there are research propositions that are put before these departments. So when I worked with e-committee, when the parliament was in session, there were multiple parliamentary questions that were put by the Ministry of Law and Justice towards the Parliament, or vice versa, by the opposition to the Ministry of Law and Justice. So all those questions, they would be transferred to the e-committee, obviously regarding anything and everything that e-committee takes up. All of those questions would be transferred to the e-committee, and then we would have to draft those answers, make an entire research project, a research report about it, and so on and so forth. So that is what the work profile of a law clerk at the registry or any other departmental office is. Now, there's one more thing I think I would have addressed it later, but I think it's better that I address it as of now. So whatever or whoever gets engaged in the registry under any of the offices forms basically a part of a waitlist pool. So whenever a vacancy arises at the judges or justices residential office, a person who works in the registry is then further transferred to the judge's office. So it's not a permanent position that you will be entirely working at the registry's office. And I think that's all. Do we move ahead? Then could you take it to slide 3 then? Okay, never mind. I'll start. So, what we start with is how do you get a Supreme Court? I mean, get a clerkship at the Supreme Court. So there are basically two or three ways you get to work as a law clerk at the Supreme Court. The primary one is obviously the exam that we are going to discuss now. The second and the third way is the judge's discretion or having personal references through the judge and then getting appointed as that specific justice's law clerk. Both these ways, the first, yeah, I think the slide they missed out. First way, you give the exam, you clear the multiple rounds of interviews and the rounds of exam, and then you get appointed at a justice's office. Second, if you have any personal contact with the judge, or if at all the judge's office releases a certain vacancy publicly and they take in interview or they take in applications based on that, that is also another way you could secure a clerkship at the Supreme Court. I think next we move is what are the qualifications to be a law clerk. These are very basic qualifications. The 8th criteria is minimum of 20 or maximum of 32 years. The education that they say is you must have completed your law course. So that could be your 5-year law course or your 3-year law course after you graduate. I think, and there's a special provision to it, which usually high courts do not, that anybody who's appearing for their final year examinations, let's say 5th year of your 5-year course or the 3rd year of your 3-year course, they are also allowed. This is on the contrary to how the high courts function. Usually, especially the Bombay High Court recently released vacancies for law clerks. They did not have this provision. So what the High Court required was a complete graduate of the 5-year or 3-year law course. While in the case of Supreme Court, if you're in the final year of your law course, you're still eligible to apply. I think that is all the basic qualification you require to appear for the exam. Next we go to is what are the number of vacancies exactly at a judge's office. So it is divided a maximum number of 5 positions per judge. 2 of them have to be compulsorily taken through the exam pool. So whoever writes the exam, those 2 vacancies are for you. The next 2 are for the judge's preference. He can have people entering serving as a law clerk through his own personal preference, etc. The last seat, the 5th one of the 5 is contingent. It is upon the judge. He could take it through the exam pool or probably through his personal preference. That is all how the seats are filled. So basically, if let's say there are 32 judges serving at the Supreme Court right now, you will have 32 into 3 of minimum through the exam pool. Now we go to the exam process. So exam basically consists of 2 question papers, 2 papers, paper 1 and paper 2. So paper 1 is basically a MCQ exam, which consists of 100 marks. Paper 2 is the theory part of it. I think Neha will take up on the theory part of the exam later. I just try to cover the first part of it. So paper 2 is basically, if at all, if there's anybody who's in their 5th year and preparing for their CLAT PGs, it's exactly the similar format of the CLAT PG that you will have your paper 1 in. So part 1 is basically 100 MCQs based on certain, what do you call it? They give you certain excerpts, certain paragraphs, or certain comprehensions based on which you'll have 8 to 10 questions per paragraph. Now, what subjects does it cover? Basically, primarily has English comprehension. And then when you come to law, it will have constitutional law, CRPC, CPC, evidence, and contract act. So these 6 subjects, again, this is not an exhaustive list, but majority of the times or 95% of it, this is what the law part of your part 1 will cover. Again, constitutional law and the procedural laws, they hold greater weightage. Again, this is not something that is provided by the Supreme Court. This is my understanding of when I had studied for the last few question papers. I felt that constitutional law still holds greater water in terms of the weightage. And then there is also, and I believe the most important part of part 1 is the current legal developments. Questions will be asked in the part 1 based on the recent judgments of the Supreme Court, of the High Courts, landmark judgments, and everything, any and everything that forms a part of the current legal developments in the last 1 or 2 years. That essentially is your paper one. Again, time for attempting those 100 questions is 2.5 hours. There's ample of time, but it takes a lot of time to read those paragraphs and then analyze, because the questions aren't going to be very specific. They aren't going to ask XYZ is written in what section. They will give you a set of facts, let's say, and they will be testing your ability to put the law into use, applying those facts, and then probably coming to a conclusion in the answer. So it takes time, but again, doable. I think Neha can talk about. Neha, do you want to cover part two, and then we'll talk about how do you tackle the questions there?
Yes.
Sure.
So Khushi, can you please move to the next slide? Okay. So the part two of the exam is the subjective written exam. It's of 3.5 hours. And one caveat is that both these part one and part two happens on the same day. So make sure that you are very well rested a day before the exam. And then you may have to go early to the exam center. And it's a very exhausting process, because imagine you're reading the part one paper for 2.5 hours, and then part two for 3.5 hours. That's technically 6 hours of test taking, right? And second part is the descriptive part of the paper. And when Hitanshu and I wrote the exam, there was only question 1 and question 2, but I've heard recently they've added question 3 as well. And so now during your preparation time, all of you please make it a point to go through the previous year question papers. But one thing you may have noticed, that before 2023, the pattern was completely different. Only from 2023 onwards have they brought in such a exhaustive and a very descriptive kind of paper, which tests your legal knowledge and your analytical skills as well. So the subjective written exam helps you to show the examiners what is your understanding of the legal materials that they give. So there's no need not be daunted by the questions that they are asking, because all the answer will be right in front of you, but you have to present it in a good manner. So the question one, if you notice here, it's of 150 marks and it is brief preparation. Like I told you earlier, the majority of a law clerk's job is to prepare briefs. So that is why Supreme Court is testing what will be your probable ability to make briefs and help the judge, right? So during a brief preparation, in the question itself, they'll give you either an SLP, which is a special leave petition, which could be either a criminal matter or a civil matter, or it could be a writ petition. So the if you look at sample question paper, the SLP itself will be of 60 to 100 pages. So don't get again afraid कि 100 pages and कैसे मैं पढ़ूंगी एक तो 3.5 hours में. But ठीक है, the entire 100 pages is not what you have to read. There are particular section by section which you have to tackle. So if you look at it, the Supreme Court is looking into the High Court's judgment and its validity. So your impugned judgment becomes very important. So what the brief preparation tests is your ability to brief the facts of the case, identify the legal issues and the ratio. And how the brief has to be prepared, the sample you will find, earlier it was on the Supreme Court website, but we checked and it has been taken down now. But do a simple Google search about a sample answer key for Supreme Court Law Clerks exam and you will find it. We also have the sample answer paper which we can share. So the brief preparation, follow the format that they have shared. That is, first you should mention the head note. The head note says that what is the SLP about? It's challenging the High Court's order, which may have granted the relief to either the plaintiff or the defendant, or the appellant or the respondent. So I think the people who appear for this exam will be in their 5th year. So make it a point that you understand the difference between all these terms, right? You can't use plaintiff and respondent together. It should be plaintiff and defendant, or it would be appellant and respondent. So these are the simple terms which you use, which will show the examiner that you understand what kind of questions they're asking. So follow the sample answer paper, which the format goes like, the first line you will write what is the case matter, For example, it might be Raj versus State of Maharashtra. And then the next line you will write SLP challenging High Court judgment allowing restitution of conjugal rights under the Hindu Marriage Act. Okay. Next, you will write the facts of the case. The first few lines you will write about the petitioner's facts. So, in a judge's office, when I was working with Justice Roy, we had a practice that we will make only neutral briefs. It means that when you read the facts, you will not make it tilted too much to the petitioner side or tilted too much to the respondent side. Your job is to cull out the facts and make it very neutral. So, but the format that the SC has shared for the exam, it specifically lays out what petitioner is saying is their facts, what respondent is saying is their facts. Your job is just to cull it out and write it in a simple manner. And then I think the next is brief facts ke baad there is impugned judgment. The impugned judgment refers to the High Court judgment which is under challenge. You'll have to read the judgment and identify the legal issues on which High Court has preferred the appellant's version or the respondent's version. And then last may you write the grounds of the SLP, which means why is the party coming to the Supreme Court? Why do they think they have a case before the Supreme Court? So all the information that you need for the third point that's mentioned in the slide will already be there in the SLP. Your job is just to read the SLP and cull out the relevant facts. And one tip I can give you is that in the descriptive paper, presentation becomes very important. Make sure that you write in a very legible and clean handwriting. And also, since the question paper itself will be bulky, for example, it's 60 pages, when you're making the note, in brackets, write the annexure, the page number from where you're taking information. Right. For example, there is one line about petitioner having title over the property relying on sale deed. And the sale deed has been annexed with the SLP. Then you write the page number of wherein the sale deed has been annexed. This shows that you have a kind of skill to make the judge's job easier, to pinpoint to them where exactly the information that you're writing comes from. So this is the first part of the paper. I think the next is a research memo, which is question 2, which is of 75 marks. So my tip would be spend most of your time preparing the brief because it's of 150 marks. You can't ignore it and keep it for the last. Attempt that question first. Then is the research memo. It's a very interesting kind of question. And what they test here is your ability to apply legal provisions, legal precedents to the fact situation. And here what they do is they'll give you a fact scenario where a client has come to you with their legal problem and you have to advise them what is their next course of action. The question paper itself will tell you what are the legal instruments applicable. For example, one question was in a check bounce case, which means that where a check has been presented and it is dishonored. So what are the legal remedies available to the client? The provisions that were given in the question paper was Negotiable Instruments Act. Even the criminal provisions of cheating, Section 420 under the old IPC was there. And next, they gave 3-4 cases which were giving the correct position of law and 2-3 cases which were not giving the correct position of the law. So your job is to read all this and then find out what is the legal opinion which is correct and proper and you think is valid, and then draft a research memo. Even for this, you have to pay attention to how the logical sequence that is going in your answer script. You can start the paper with saying that these are the questions that I will be addressing, question A, question B, and then go to question A. Why do you think the answer is yes or no? So one tip is that to give your answer at the forefront. Yes, I believe filing a check bounce case under NI Act is a valid proposition or valid proposed action. So then you justify it with your argument with the relevant statutory provision and case laws. And then in the end, you write the conclusion. So I'm sure in your 5 years of law school, you must have faced exams where similar questions were asked, or in your research, on your internships, The associates must have given you research questions and you've prepared research brief. And even if any one of you has not faced such kind of questions before, just go through the sample papers and it gives you a proper example. So it's all about emulating that in the real exam paper, nothing more. And then I think the third question is the analytical question, which Hitanshu will tell us more about.
Yeah, right. So third question, which they've said is an analytical question. It's basically a sort of essay writing that you are expected to do. So what you will be given is five options, which will have certain positions of law, either decided by a Supreme Court judgment or yet to be decided by a Supreme Court judgment. That's up to their discretion. Now, what you are expected is to do is to select one of these topics and then go on writing about the legal provision. Was it settled? How was it settled? On what grounds was it settled? What are the legal provisions that apply to it? And what in your opinion is the conclusion, whether the Supreme Court was correct in doing that or they made a certain legal error in forming that judgment. Now, what the assessor is expecting out of you is your understanding of how law is applied, your understanding of how law could be applied or could have been applied or ought to have been applied in a certain situation. Now, this question also majoritarily uh, comes from constitutional judgments. So, especially to prepare for this judgment, this question, I believe understanding of the major landmark constitutional judgments would help a lot because when I checked the last year's question paper, which was when this third question was first introduced into the examination, all the five options were majoritarily from constitutional law. And that is the trend. I think in the scheme of the last year's examination, they had also mentioned that the last question would be expected as a constitutional law question. I think that is all in the third question. There's nothing much that I can also add to it. It's basically a essay writing question where you will be given a certain position of law and you're expected to explain the position of law, put your knowledge of law into use, give out cherry points when you actually draw out the provisions of law that were used by the Supreme Court or that apply to the present situation. I think that's all in the third question. There's nothing much I can add to it. It's a very basic, and it's the score. The marks I think for the third question is 75, right? Yeah, it's a 75 marker question. Even though the word limit for the last question I believe is 500 words or something, that is the expected by them. So the biggest task is for you to put out all the knowledge that you have in a mere of 500 words that would form, let's say, just one side of a page or at max two sides of a page. So that is the biggest task, to fit in all the provisions, to fit in what the courts have had to say on the provision. So that's all. I think we could, what comes next is the selection process. Okay, this is the most important part. There is individual qualification for both part 1 and part 2 of your written examination. For your part 2 paper to be checked, you need to score a minimum of 40% in part 1. That would be a score of 40 marks at least in the MCQ examination, that is your part 1. If you fail to score 40 marks or 40%, your second examination would go entirely unchecked. It would not even be touched by the assessor. Now, let's say once you've scored more than 40 marks in your part 1, your part 2 comes into assessment. For in that situation, for you to qualify in the further processes, you need to score a minimum of 50% in the part 2 examination. That would mean any score more than 150 in the 300 mark part 2. After this qualification takes place, after you've qualified both part 1 and part 2 according to the criteria, what comes later is a combined score, and based on that combined score, a certain cutoff is set by the Supreme Court. Usually goes around 250, I believe, because that has been the trend for the last couple of years at least. And then a certain list according the scores is released. What comes after the scores is you will be, so whoever has qualified, I believe when me and Neha we appeared for the examination, 250 candidates were shortlisted after the written examinations. Last year, the 2024, if my knowledge is correct, they had shortlisted a total of 450 candidates. So the number is not something that they will stick to 240 or 250 or 300 candidates. It's entirely up to the Supreme Court or whatever the cutoff reaches. After the list is released, the Supreme Court's recruitment cell, they will reach out to you, especially over mails. So please make sure you keep checking your emails, because and many of the times Supreme Court's mail, they also go into your spam folders. Please pay attention to that. So they will be asking you to give a certain preference list according to you for the judges you want to work under. So there's a certain deadline within which you have to give a preference list of the judges. So you, let's say if the strength currently is 32, you will be giving a preference list of 1 to 32 as per your preference for which judge you want to go under. What follows is the interview process. I think Neha can take the interview process.
Okay. Thank you, Hitanshu. So, like he mentioned, in our time, 250 candidates were shortlisted, and roughly we would expect that each judge would have interviewed at least 10 to 15 people, and then they will select two or three law clerks that they want for their office. So, I was contacted by the PS of the judge, who is a private secretary, and they directly contacted me and make sure that whenever you get a call from pin code from like so the calling from Delhi, you pick it up, because I thought it was spam and didn't pick it up for 6 times. Then in the evening called them back, and they told that your interview will happen and it will happen today in the evening. Will you be ready to take it? And back then I was working at a firm. But then, like we know that this is all like a one-time opportunity, and although I tried to tell them that can we have it later, but they were very adamant that it's the judge of the Supreme Court. He has decided that he'll take the interviews now, so you make sure that you're free. So I think within like half an hour or 1 hour, the interview took place, and luckily the judge I who interviewed me, he decided that it will be a personality interview where he wants to assess the law clerk coming into his office. So the questions are mostly about my previous experience, what are the subjects that I'm interested in, and what am I currently doing. And he also asked about my hobbies and what are my plans later on. So it went around 10 to 15 minutes, but it was more of a personality test. But it differs from every judge. So, like we know, there are 32 judges. Each of them may have a different criteria to selecting you as their law clerk. So, in some offices, they might actually check your legal knowledge. So, for preparation for the interview, make it a point that you're abreast with the legal developments of the last 1 year, and be confident about the things that you mentioned in your CV. I'm sure when you registered for the exam, you must have uploaded your CV, or there's a chance that later on the PS may ask you to send your CV, right? So be thoroughly prepared with your CV as well. And so when we wrote the exam, the timeline was not correctly followed, and I think in July my interview happened, and within a week I was asked to join the office. But luckily in your case, the exam is happening now in March, and later on there is a time that through May, I think the interviews will take place, and you'll all have sufficient time to prepare for each step of the process. But I think the opportunity to even have an interview, have a talk with the Supreme Court judge itself is such a privilege for any of us as law students. So I would say that it depends from judge to judge, and I had a personality test, is what I would like to say. And I think the next slide, if we could move on to. Yeah. So while preparing for the exam, I think a lot of people have asked me personally, what are the areas that we have to focus? What are the last minute preparation tips that we need to follow? So as we already highlighted to you, the exam tests your legal knowledge in terms of what you've studied in your 5 years of law school. It's not testing anything that a law professional or a lawyer is expected to have. So the subjects that you're testing are also like constitutional law, CPC, CRPC. So in these subjects, I think you need to focus on core concepts, such as like maybe in CPC it could be jurisdiction, the kinds of courts, the how does a suit travel as a plaint to the final decree, what are the stages. So overall have a broad idea about what each statute covers, and don't focus too much on which book should read and which book should I thoroughly read, because there's no particular book which can help you. The first book I think which both of us were thinking we could recommend is just the Bare Acts, because the Bare Acts and the provisions, if you go through them once, at least you'll have an idea what it'll brush up your legal knowledge. I'm sure during law school you've given your exam, so everything you've studied, but now is your time to brush up those concepts. And in contract and torts, go through the landmark cases. And the test is not testing your specific knowledge, but they want to know that you are aware about the main concept. And I think one thing we forgot to mention was the current legal developments also is something that they test. So I read live laws legal updates maybe for the past 5 6 months, so that I do not miss any landmark cases. And I think Supreme Court has also uploaded a list of 30 cases which were relevant, I think, in the last year. So go through that as well. And Hitanshu, if you have any more tips for the focus areas.
Yeah, so right, especially for part one, if we consider what they're expecting is not for you to know specific section numbers and specific provisions. They're just trying to understand if you're able to put the core concept of a law into practical use. That is all they're trying to expect. So to get out of you. Even if you go to the Supreme Court's website, under the Judicial Clerkship tab, you will find the question papers of the last few years. When you read the part one question paper, especially, you will find that whatever the excerpt or the paragraph is, especially in terms of subjects like contracts or IPC or the procedural laws, it's a set of facts for usually. They're trying to, what they expect out of you is you take those facts, put your understanding of laws, and then come to a conclusion that suits the best in that case. So, as we said, as Neha said, right, starting with the Bare Acts first is the best strategy that you could actually use, because Bare Acts is where the real language of law is going to be. That is where, again, when I say Bare Acts, we don't mean that you mug up the sections or the provisions in the right sequence. It's just that you know the language of law. After you've covered Bare Acts, obviously you understand what the tone of a specific provision or a specific statute is. Once you understand the tone, you understand what that statute is actually applied for. I think that knowledge is enough. They're not trying to hire lawyers to fight before the judges. They're trying to hire law students who will actually assist the judge into a certain procedural aspect of coming to a specific judgment, right? Apart from that, this entire exam, especially part one and even for the part two of it, is more, it leads more towards your checking your understanding or your knowledge about whatever has happened in the past couple of years, a year or the last couple of years. So having awareness about whatever the judgments were either passed by the Supreme Court or even the High Courts in the past 1 year, or whatever judgments the Supreme Court and High Courts are yet to pass. So there are cases where constitutional benches have been framed and they are reserved for judgment. So even those cases, they form a good chunk of your question paper. Obviously, if not certainly, but they might form a good chunk of your questions. Again, how do you go about the judgments? I think the best resources for this I would suggest is go to Bar and Bench or Live Law. All the law schools usually have subscriptions to Bar and Bench and Live Law. So they have these annual summaries of all the judgments of the Supreme Court or High Court. So either they have it court-wise, they also have it subject-wise. You could just go there. It's not necessary that you've read the entire judgment and you know all of it. even if you have the knowledge of what the judgment was talking about, what were the issues before the court, what was decided, and how was it decided. I think even that knowledge is more than enough for you to get through part one and part two of the paper. And again, thirdly, for part two, and this was my experience because whatever list, so we have 6 major subjects that only forms a good chunk of your part one. When it comes to part two, there's no exhaustive list of subjects that will form a part of the question. Because I remember when we wrote the exam, the research memo question was apparently from family law. So family laws does not majorly, or it actually doesn't form a part of your part one of the exam. But the research memo question, it had family law. It was based on family laws. Again, for the research memo question, you are given the statutes, but it is always helpful and it is always better that you are aware of basic concepts of family law as well. So I would suggest make sure you are well versed with these 6 subjects, but additionally, whatever forms a major law subject in your law schools, there are family law, torts, let's say arbitration, let's say company law. Please go through these as well. This can be your secondary reading, but as a part of your primary reading, please go through the 6 subjects that have been mentioned in this slide, and additionally all the judgments. Again, we're referring to the list of judgments that was released last year. My understanding tells me that that was an experiment by the Supreme Court. If they had to release a similar list of judgments this year, they would have released it by now. If it is not released yet, that means at least I could assume that they are not going to release it yet. So what you could do is refer to the last year's list as well, and probably then find your own sources to read up about judgments of 2024. So that would make sure you're covered with judgments from 2023 to 2024. That would give you a good knowledge of judgments of 2 years. Yeah, I think, and I missed one point. Right after you're interviewed for the judge's office. So obviously there are, let's say, 250, 300 candidates shortlisted. 30, 35 or a max of 50 would go to the judge's office. What happens next is whoever is either not selected by a judge's office or whoever was not called for interview by a judge's office, a separate list will be created. The Supreme Court, they will contact you again saying, asking you if you are willing to appear for the interviews for postings in registry. Now, what is the registry pool? Registry's pool of candidates is basically a waitlist pool, as I said earlier. Whenever a vacancy appears or comes up at a judge's office, who gets a chance to go and work at a judge's office is someone who's posted in the registry. So when you clear your exams, when you give your interview, unfortunately, if you're not selected by a judge's residential office, you will be receiving that mail. Please make sure that you appear for that interview as well. That interview is taken by the registrars of the Supreme Court. I believe so you have 3 registrars. When I appeared for that interview, I had 3 registrars. I could only recognize Anurag Bhaskar sir. I think there were 2 more. I couldn't recognize them. I never checked it later. But you will have registrars of the Supreme Court who will be taking your interviews. Again, my interview was a completely technical, I would say, technical questions based. So they asked me questions of law. They asked me why would I like to join, what are my plans, etc. So the basic questions aside, they do check your knowledge of law in that interview. I think that is all for the entire examination process. In terms of preparing, I believe, again, as we said, right, concepts of law and knowledge of whatever has happened in the legal world in the past couple of years is more than enough. How do you start? Please start with your bare acts. Do not focus more on learning the sequence of provisions, but try to understand what the concepts of laws are. Apart from that, after you're done with the bare acts, I think it's a personal choice for you to choose whatever way you want to take your preparation is. Personally, if I say, when I gave the exam, I was preparing for my CLAT PGs. And as I said, CLAT PG question paper and the part 1 of this exam's question paper, it's entirely the same. The structure, the syllabus, the expectations out of the person attempting the exam, it's entirely the same. So I found it very easy or very relevant for me to go back to my CLAT PG preparations and just revise it for this exam, right? If at all there's someone who's appearing for CLAT PG, you could use the same strategy. It doesn't hamper your preparation in any sense. It's just the same. One more thing that comes out of my personal experiences is when we talk about preparation about this exam, you need to understand that whoever is going, like, who all are giving this examination, when you get selected, when you join the office, you'll find that majority of the candidates who are appearing for this examination are judiciary aspirants. I mean, Neha would probably have had the same experience. At least this is for what I experienced at the Supreme Court. So most of my colleagues, they were judiciary aspirants. So naturally, a person who's been preparing for the judicial examinations for, let's say, the last year or a couple of years or for the last 3 years, he has a different level of understanding of legal concepts. So if you want to make it through that shortlisted candidates of, let's say, 100, 200 people, you need to ensure that your understanding of law, your ability to apply law has to be at par with someone who's been into, rigorous study of law for the last at least couple of years. When you understand that that is the level that you need to match, then obviously your preparation would go into a certain direction. So again, apart from understanding the exam, it's also important for us to understand whoever or who all are appearing for the exam. It's the same strategy that civil servants use for their civil service examination, right? To understand your competition, understand the exam, and I think you'll be done there. I believe that's all from my side.
Hmm. I think we can move on to questions. But before that, there is one important caveat. I think many people are very interested in the clerkship exam, but one thing is that be ready for long and grueling hours. Some offices expect you to come to the court in the morning at 10:30 a.m. and then once the court ends, go to the residential office, which is not at the Supreme Court, which is somewhere else. So there you sit and you work till 9 o'clock, 10 o'clock in the night. And then Supreme Court also has this complement list concept of supplementary list, which means that additional list of matters come up at 10 o'clock in the night. So as law clerks, once you go back home, you have to work on those briefs and send it to the judge, so that early morning when they wake up at 6 a.m., they have a brief ready. So you have to be on your toes on like Monday, the days before Mondays and Fridays, or even Tuesday, Thursday. Generally, supply list comes out at 8 or 9. So work doesn't end just at like 7 o'clock or 8 o'clock traditionally in like some offices. Uh, so this is one aspect of the work. But then you also have many perks. First perk is obviously the salary. If you're just a freshly graduated student, you'll be getting 80,000 being a law clerk. And then if the judge recommends your continuation for another year, the salary gets increased to 90,000 as well. So along with the salary, you may also have the perks of staying, getting to go to the Supreme Court every day, and then and you have the opportunity to sit right in front of the court hall. I think now law clerks have a space right in front of the, like, just below the judges. There's a specific seat for law clerks and even judicial interns to sit and listen to the matters. So it's a very good opportunity, and that's why, like, I think now there's 1 month. If everyone puts in the effort and follows whatever strategies and tips that we have said, it should be a good opportunity in the end. And I think don't be overwhelmed too much about so many resources that are there outside. Like when we wrote the exam, ours was the first batch which was writing it in the new pattern, right? So we had the advantage of not having a lot of information. Now you have 2 years of people who have already written the exam. Everyone's telling different things. So don't get too overwhelmed or diverted with a lot of advice people are giving in. Just spend those hours reading the law, reading the case laws and everything. That will help you more than finding out what is the strategies to ace the exam. In the end, the strategy is just to figure out what the exam is asking you and how you can give your best for it. And I think we can go to the questions now. There are a few questions in the chat box. We can start with that.
Yes, ma'am. The major question is ki will they be following previous CPC CRPC or
Hmm.
will they be based on BNS or BNSS?
Okay, so at today morning, I saw a notice on the Supreme Court website which says that the syllabus is the same as they mentioned in para F of the scheme for law clerks exam. So I think it is a confirmation that it is the old CPC, CRPC, IPC itself that they will be testing. And one tip is that every make sure you keep refreshing the judicial clerkship section of the Supreme Court website. I think Bodhi has shared it on the chat section as well, because all your important notices and notifications keep coming up there. So the answer to that question is, I think the old CRPC IPC is what they're testing. Hitanshu, if I'm not wrong.
Yeah, I think it's they've just uploaded that notice.
Hmm.
You could just check the notice. If, apart from trusting us,
Yeah.
it's better that you go to the website and check it yourselves. It's right there. I also saw Bodhi put up that, so you could just check that.
Next question is, do we have to go through each and every section of all the bare acts or just generally important topics?
I would suggest go through the bare acts at least once, but it's not as I said again, right? You don't need to know the specific sections of a specific act. It's just that you need to know what the concept is. So when I talk about, let's say, a provision of contracts, I need to know what is unjust enrichment. I need not know it's section 71 or 72. Okay, if I know it, it's great. But what's the flow of performance in a contract, or what does specific performance mean? When is it applied? When can you have specific performance? All these concepts, even if you're aware about these concepts, I think it's well and good for you.
Yeah, true.
Next one is ki we were talking about that cases which Supreme Court releases. How these cases are relevant to this current exam and how we are supposed to read it.
I think no legal knowledge is a waste. So even if it's dated, that it's just 1 year ago, just skim through stuff. Like, it's not about memorizing the case laws or identifying what is the ratio, who are the judges. Even if you skim through the cases that they have given, you'll identify what kind of cases Supreme Court thinks is the most relevant, the most significant, right? So first priority will be of constitution bench cases. In the last year, when I was working with Justice Roy, there were three, I think, three 9 judge benches that decided so many important questions of law on property, on mineral rights, and alcohol, and the taxation involved. So these definitely go through, read them. And there were few 5 judge benches, there were 7 judge benches. So in the last 1 year, there's a lot of these constitution bench judgments that you definitely need to go through. And like Hitanshu said, Live Law has that annual digest, which tells the important cases of the year. So go through that as well.
Uh, I hope this doubts are clear. Apart from this, some people have raised their hands. So, Prinati Thakre, if you can unmute and
Yeah.
tell.
Hi. Am I audible?
Yes.
Okay. So, my question was actually, I have a twofold question. So, you have clarified that we need not, like, for example, read every single section of every single law. But in terms of constitutional law, you've also stressed how important analytical skills are. So, my question is, how do we ensure that, like you've also said that Bare Act should be our primary source of, reference. So how do we ensure that while reading bare acts, we are also, sort of like improving on our analytical skills? So like, do you have any tips or any advice on that?
So along with the Bear Act, you can supplement it with any of your textbooks that you already have, or go to your library and then take out any. I'm not saying big commentaries like for. You need not pick up MP Jain, which is like so has 10 volumes, and go through it. But if there are some concepts, for example, basic structure, which you may not find in the Bear Act, right? Like in the Constitution of India. So this is some concept wise you may have to go through and clear some like have more knowledge of it. For this, you will definitely have to look into the textbooks themselves. You can identify major concepts in constitutional law and how the various amendments that have come, the major ones. So where barracks are not sufficient, if you find that way, you can go through the textbooks and other books that you already have. These are not subjects which are specialized law. They're not testing you on public international law or some trade law or something. These are concepts you've already studied. It's only about like brushing up the topics, and the level of the exam is also not too high. They are testing your ability to read the question, which is very detailed, and arrive at the correct conclusion. So this will come only with practice and having the basic legal knowledge, I think.
Yes, I understood. Thank you, Neha. And I just have a quick follow-up question, which is that, the stipend which is paid to the research clerks come
Mm.
assistants, which is like 80,000 per month. Is it the same as what is paid to the people who work in the registry, or is there a difference?
Hitanshu would be able
It's
to
just the same.
same. Yeah.
It's the same.
Understood.
So wherever you are employed, it's just the income is the same.
Yeah, because your position is exactly the same. Even people who are at the registry are law clerks come research associates with the Supreme Court. It's just that they're not working at the residential office of the judges.
Okay, understood. Thank you.
Yeah.
I guess Chinmay Farke also have some doubt.
Okay, hello, am I audible? Okay, so ma'am, I love the way you guided right now us about how to study and etc. But the one thing that I want to ask is, I have heard from few of the seniors that after clerkship, like once the clerkship ends, there are some barriers or there are some limitations to start our next career, right? So if you want to practice or if you want to be the judge, so are there any limitations after this clerkship? Can you please elaborate it, because I'm confused a lot about it.
Okay, so I don't think who has given you this advice, because clerkship is considered as a very golden opportunity which helps you in every aspect. For example, I am interested in litigation. So the soft skills that I have picked up in the clerkship will definitely help me when I join a new office. Maybe like how to read briefs and everything. If you're worried about how, if you're spending 1 year with a judge, will it help in my litigation? Or maybe you're interested to be in the judiciary. I think that 1 year is very valuable opportunity where you're at the Supreme Court. You're reading briefs from all over the country, and many of my colleagues are also applying for LLMs abroad. And if your work is very good and commendable, the judge themselves might give you a recommendation letter, which might help you with the your LLMs. So I don't think it will hamper your future career. It's just that you have to make a choice. What is your future career after clerkship? What is your goal? Do you want to go into the judiciary? Then you may have to prepare for that separately, right? But yeah, one caveat is that if your goal is solely for judiciary, the hours that I told you how the clerkship demands so much of your time, you may not get that opportunity to prepare for the judiciary solely. But in the end, it's all about time management and what your priorities are. So in the end, anything can be manageable. It's just that you have to figure out a way, I think.
Okay, thanks. I'm so sorry I got the wrong information.
No,
Uh,
no, it's okay. You go tell your
also,
seniors that
yeah,
it's
sure.
not that way.
Also, currently I'm in a fourth year.
Okay.
So, can you please tell like any kind of a habit that I must follow from right now so that it will help me to pass the exams?
I think following live law, make it a habit. Even as lawyers, like very established lawyers, also make it a habit to read live law or bar and bench, be updated with legal updates. So this habit you can build right now itself. I think that would be one tip.
Okay, and one last question was that, is there really any kind of a importance of giving a reference to the, like while applying for the exams, right? So after, like during the interview, we have to give the reference of some lawyers or some judges.
No,
So
no, that
there is no like like one of my friend is a first generation lawyer, and he's very anxious right now that if I don't have any kind of reference, it will be any kind of problem. So
Mm. You can tell your friend, even I am a first generation lawyer, so I didn't
okay.
they didn't ask me for any reference or anything. Even like immediate fresh graduates have also been appointed. Like one of my colleagues was a
Mhm.
2024 grad and she got appointed. It's all about, in the end, you're getting this opportunity of to show that you're meritorious. And it through the exam, I think it's a good opportunity to get to these places where ideally their references are not required.
They are going to check our brains.
Yeah.
Okay. Thank you so much.
Due to restriction of time, we'll just take two more questions. Gaurav, please unmute.
Oh, yes, sir. Hitanshu, I wanted to ask you, since you said that the cutoff was 250 marks, so was it with the 75 marks analytical component or without it?
No, I believe the exam that we gave, me and Neha, it didn't have the third question. So it was 150 marks for both the questions in part two, uh,
Also,
excluding,
okay,
yeah.
yeah, yeah, thank you. Also, when was your interview conducted for the registry? Was it
So, so back
was it
back in
along with the
2020,
law clerks, or was it separately after a few months taken?
so it's a process that they follow. First level of interviews takes place by the judges as well, judges obviously. After the judges have selected a bunch of candidates, or after the vacancies have been filled up, a list comes up, and thereafter are the interviews for the registry taken. So obviously, judges take the interviews first, and then the registry interviews take place.
All right, so one last question, sir. I wanted to ask you, since last year also the Supreme Court released 450 students shortlisted for interview, right? So what is the and this list is as per merit. So what is the
Right.
possibility? So what is the possibility of students which are below in the ranks to also get clerkship?
See, honestly, when a judge has to call you for interview, apart from your CV, is also primarily going to check what's your rank in the exam. That forms as your primary characteristic of showing your merit. But there have been chances where, even though the ranks were pretty uh, low, they've still gotten to a judge's residential office. So one of my seniors from college, uh, he couldn't make it in the top 100 or top 50. I think his rank in the exam went pretty below, but then he ended up working at Justice D.Y. Chandrachud's office. So that isn't really a specific or a certain math that goes. There can be chances if your CV is that great that the judge, irrespective of whatever your rank is, he wants you at his office, and he will obviously take. But
Okay,
again, it is obviously
so are
suggested
all
that you make sure you get a
yeah,
higher rank.
but so are all the 450 candidates called for interview, or only the top performers, top some?
Uh, so not really. So it is for the judges' residential office. I believe uh, whatever the judge feels, whoever the judge feels he wants, he calls for interviews. After that, the registry obviously asks for your consent. If you're ready to appear for their interview, then all of those are interviewed. And among those, a specific few are given appointments at the registry.
Okay, all right. Thank you, sir.
Sohail, hello. Sohail, are you there?
Yes. Good, I think, good evening. Okay, so sorry to interrupt. I'm from Pakistan, so I'm sure you don't mind. Do you people don't mind it? So I'm a fourth year the law student from the Pakistan. So I just saw it from the LinkedIn from my connections, and there's going webinars in India. So I found it interested, to just attend it and know about the Indian Supreme Court. Contrary to the Indian Supreme Court, in Pakistan, the clerkship is simple. It's not something like so much complex of exam, and we have to just write like a SOP, and in which we have to just tell why we are interested in it, and the judge will see it, and they will call it whoever they want. So that's all. But I think on your side, that is more competitive, like conducting the exams, and that's it.
So we're so glad that you joined. Thank you so much for joining.
Yeah, I'm very glad to know about the Indian Supreme Court and you guys.
Thank you so much.
Thank you.
Hey, do we have more questions?
No, sir.
That before we end, obviously, there's just one thing that came at the top of my head. I've observed that recently a lot of people, they've started up coaching centers for the clerkship examinations and whatnot. To be very honest, I mean, it's again your own perspective. It's a personal prerogative that do you want to take those coachings up? But if you ask me, do you need those coaching classes and those entire 3 month packages and 4 month packages for a clerkship exam? Absolutely not. Make sure whatever you are able to strategize, however you are able to strategize your own preparation method, get into preparation, and I think you'll be able to do that. There's no need of those coaching classes and coaching centers as for this exam at least. That's all, I guess.
So, can we take just one doubt?
Yeah, sure.
Yes.
Yeah, sure.
Shivangi, please unmute.
Right. Hello. So thank you so much for this insightful session. I had this one doubt that for someone who has been placed, so I know that this would be a very big shift in career, like being placed in a corporate sector to going into a sector which is completely related to judiciary and litigation. Would you advise this shift? And what is this? What is the criteria pertaining to sanad? Like, do we have to surrender it before appearing for this exam?
Neha, do you want to take this up?
Okay, so I was also practicing before I came for the exam. So the scheme specifically says that the time period that you spend as a judicial law clerk, it will be counted for your advocates on record exam practice requirement. So there is no need to surrender your sanat, but there is a condition that you can't practice during that 1 year. You can't file wakalatnamas or sign or even give a legal advice or anything because you're a contractual employee of the Supreme Court of India. So, although there is no need to surrender your sanat, you can't be a practicing lawyer.
Thank you. And also the first question that was related to the shift in careers.
Okay, so I think if you go check on LinkedIn, there are many people who have been in law firms and then they join the judicial clerkship because they want this 1 year of experience. Maybe their career goal is next to go for an LLM, or maybe they just want a break from the corporate law or anything. So the clerkship experience, like I told you, those were my responsibilities. So it's up to you. Do you want to explore this side of the law, and how do you think it will help with your future career goals? So it's like a very individual choice, but there are many people who have served as associates in law firms and then they come and join a judge's office. So it's not unheard of for maybe like a finance someone in the banking team to maybe come join and become a law clerk, right? Because even fresh graduates can become law clerks. So there is no disadvantage, nor there could be advantages if you're already working maybe as a lawyer and then coming for a clerkship because you understand the practice, the nuances of the practice. But it's not something that is disadvantageous.
Thank you so much.
You're welcome.
So, thank you so much, sir, ma'am, for entertaining all the questions. Before we end, I want to express my heartfelt gratitude to both of you for sparing your precious time with us and telling us about all about the law clerk examination and your experience in it. We look forward to have more such sessions so that we can reach to people who need us. Secondly, I want to express my gratitude to Policy and Law Network Foundation for bringing such informative sessions. Also, Legal Aid Committee, Maharashtra National Law University is pleased to have you guys here to know about law clerk examination. And lastly, our beloved participants, you are too good to be here. And it was too informative and engaging session. Thank you so much.
Thank you, everyone. Yeah.
Thank you
All
for
the best for
having
the
us as well.
exam. Yeah. Mm.
Stay inspired and have a good day.
Thank you, Kushi. Bye.
Bye bye.